I would now like to welcome and introduce Katie Johnson, who is the Chief Legal Officer and Chief Member Experience Officer from the National Association of Realtors. And I think Katie has some great follow-up information to the points also made by Jessica. So with that, I am going to welcome Katie.
Good morning. How is everybody? Thank you for inviting me to your meeting this morning. Anne-Marie said that I have 15 minutes to talk to you about all the important risk and legal stuff happening in the industry. I can do hard things, that's for sure, but that is a special challenge to be sure. So with 15 minutes, I'm going to use some NAR resources as our guide so that you have a place to go back to and read and watch the information I'm going to highlight. And then, of course, we have a fabulous legal team here at NAR, and you are always welcome to reach out and ask us any questions you might have about the information we're providing. So hopefully you can see my screen, which says Hot Topics in Broker Risk Reduction. This is at nar.realtor. You go to nar.realtor and you search Hot Topics or Hot Topics in Broker Risk Reduction, and you will find this very valuable tool. It includes the most pressing risks that could impact your bottom line, meaning the risks that will save you money if you know about them and take steps to avoid them. And we update it at least twice a year, if not more frequently. So starting with the top of mind, top risk, top issue of the day, competition in real estate. Very briefly, I will remind you all that we NAR and 4 corporate defendants, Remax, Realogy, Berkshire Home Services, and Keller Williams, are defending 3 major class action lawsuits. These class action lawsuits, 2 of them purport to represent sellers, 1 of them purports to represent buyers. They all represent the interests of class action attorneys, to be sure. But what the underlying allegations are that the services provided by Realtors is too low and the compensation provided is too high. And they claim that the rule and practice of the listing broker compensating the buyer broker has led to artificially propping up the use of buyer brokers. They say buyer brokers are not necessary anymore because consumers can just find their home on the internet. They say buyer brokers wouldn't be used but for the rule. They say that if buyers had to pay their brokers directly out of pocket, as opposed to them being compensated by the listing broker or the seller, then they would necessarily negotiate those prices down because of the lower level of services that they provide. And they claim that the process by which listing brokers offer compensation to buyer brokers via the multiple listing service or local broker marketplace, as we call it, that is anti-competitive in and of itself because other countries don't have it. And in other countries that don't have a multiple listing service, they don't have buyer brokerage and they don't have, and they have lower commissions being paid to real estate practitioners. So you've probably heard me say all that before because we've been defending these lawsuits for nearly 5 years. And then you've also heard me say, which I still firmly believe, that these cases are wrong on the facts, wrong on the law, and wrong on the economics. And we are spending a tremendous amount of resources and time and energy to prevail in these cases. The first case is coming to trial, the first case being the Missouri case and pertaining to just sellers located in Missouri using Missouri MLSs. That case is going to trial in October. So there will be an outcome, which I'll talk with you briefly about. The Illinois case, of which I believe that your MLS has been tapped to provide discovery, documents, information, and data. In that case, that will not take place until 2024. So we have another year before that even goes to trial. So looking ahead at October in Missouri, there's a number of possible scenarios and outcomes. The best, and I think likely, is that we prevail and that we convince the jury that the plaintiffs have it all wrong and that the process by which consumers have been served in America is not only lawful, but has always served their best interests. And that is the best case scenario. If we do not prevail, then there could be a number of other possibilities. There could be damages award. That damages financial money award would be against the defendants, not against any other associations, not against any other MLSs. Only the defendants, only the parties to a lawsuit can be responsible for the outcomes of the lawsuit. So that would be against us. There could be injunctive relief. Injunctive relief could be anything. It could say that NAR cannot have a rule providing for offers of compensation over the MLS. It could say that the 4 brokers involved can no longer compensate buyer brokers in the MLS or otherwise. It could say that that not only can NAR not have a rule, but they must prohibit it. There's several possible outcomes. But how it happens is that there's more arguments and briefing once the finding of the judge is determined, and then there will be an appeal. So we would move to stay the injunction, stay the damage award, and appeal the case. And quite frankly, if or when we prevail, the plaintiffs will move to appeal. And so then there will be more litigation and likely many years before there is a final resolution to these issues. But what are these issues? The underlying issues that we're talking about is a challenge to buyer representation. The underlying issues in all the cases is saying that buyer representation is not valuable to consumers. And so what do you need to do now? What do you, as a Realtor member out there, need to do now? You need to be proving that they've got it all wrong. You need to be speaking with your consumers and your sphere of influence often and accurately about the services you provide as listing or buyer representative, about the value you bring to the transaction, and about how your local broker marketplace works and why specifically it works for both sellers and buyers. Why does your MLS benefit your client specifically? And we have a lot of tools to help you do that, which I'm going to show you real quickly here. But in addition to improving your game on how you articulate your value, what value you actually do provide to your clients in every instance, you need to use buyer broker agreements. I do believe that you do, that you must, that your law likely requires it, but you need to use them timely. This is the time to reevaluate those buyer broker agreements, make sure they contain all the pertinent information about the services to be provided and the compensation specifically, how the compensation is, make sure you give to them at the very first point of contact, meaning before you start to perform the services. That is the most effective way to avoid risk, to avoid liability, and on a very positive note, to ensure that expectations are clearly articulated and met, but through this written signed agreement. That's what we need you to do. And that's what you can do to prepare yourself for any outcome in this litigation. So let's look briefly here at the website. As I said, Hot Topics in Broker Risk Reduction gives you some tenets of the messaging, and it will refer you to this incredibly helpful website, Competition and Opportunity in Real Estate. And so you go to competition.realtor. That's the second. So you got nar.realtor, Hot Topics and Broker Risk Reduction, competition.realtor. It is a plethora of information on all of the important components of what you do, what MLSs and local broker marketplaces provide, and how it impacts positively consumers and economies and communities. It is organized, and I don't have time today to go through it all, but it is organized into our three main messaging: how you and your cooperation in local broker marketplaces fosters competition and the benefits that competition has to consumers and communities, consumer access and opportunity. MLS, local broker marketplaces, the greatest tool for consumers to have the most transparent, comprehensive, accessible, accurate information of inventory in one particular area. Without it, and without encouraging or incentivizing brokers to participate in it, consumers will be harmed. Realtors as champions, you are not only providing a very important service to consumers in the most complex and expensive transaction that they will ever have, you are also building your communities. You're volunteering, you're living where you work, and you're trying to make those places desirable for other people to move to as well. And so you, more than any other profession, go above and beyond. This also has FAQs, articles, and social media messaging that you can use. Anne Marie and every association executive and MLS executive also has 3 very comprehensive toolkits, one for each of these tenants. Those toolkits are 25 pages of social media posts, radio ad scripts, TV ad scripts, other poster designs, key messaging statistics, and any other communication tool we think would be helpful for associations or MLSs or brokers to launch their education campaign. Specifically, I want to call out Lee, who I had the opportunity of going to Gathering of Eagles, and where I met Lee, and he had a very great idea regarding this handout. This is called 179 Ways Agents Who Are Realtors Are Worth Every Penny of Their Compensation. And this is a very savvy brochure that really lists all the things, especially that listing brokers do. Lee recommended that we put it in our signature block. That's a great idea. I passed along that recommendation to all association executives so that they would consider encouraging their members to include a link to this in their signature block, or to post it on their own website so that the link goes to their brokerage website. There's another one of these handouts coming soon, specifically about buyer representation, and 179 ways buyer representatives are worth every penny. Another tool that I want you to know about is real estate commissionfacts.com. So again, the underlying issues in this litigation is around how buyer brokers are compensated. And the question is whether or not that's in the consumer's best interest. We know it is. And so you need to explain it to them. How is this compensation working, and how is it in the consumer's best interest? We created a 1-page website. This is only totally geared towards explaining the compensation model in America. And it will likely, based on our search engine optimization tools and tactics, it will likely be found if anyone is searching information about the litigation, the class action lawsuits. And last but not least on this topic, we have, another amazing resource for you to all know about is NAR's Window to the Law series. Each month we put out, our lawyers put out a 5-minute video, 5 minutes or less. It's never more than 5 minutes. That is very succinctly tailored to alert you to the risk, explain some background about the risk issue being discussed, and provide tangible tactical steps to reduce or mitigate that risk. It is a shareable resource. It is a very important resource. And in May, we created the benefits of using a buyer representation agreement. If you have any agents on your team or in your offices that need a quick primer on why it's good for them as well as the consumer, please go ahead and share this Window to the Law video. Okay, so we are competition in real estate, and I think I have 3 minutes left. So we'll go back to the hot topics in risk reduction. Antitrust, again, this part unrelated to the lawsuits, but it's always a good reminder to know what could get you in hot water about your brokerage activity and your brokerage discussions. So we have a lot of great risk reduction information and resources here, including Antitrust 101 for real estate professionals. Cybercrime and wire fraud. We know that no one is immune to this risk. Every company and organization is fighting these attacks daily on their systems. And you likely know someone, if you aren't someone yourself, who has become victim to ransomware or wire fraud, where your finances or documents are tied up by some hacker. And therefore, this resource has risk reduction tips and tools, especially to help you and your consumers avoid that risk in closing. Again, look at all the resources, A Window to the Law, and many others, including a cybersecurity toolkit that will help you create processes and policies to protect your information. Copyright infringement remains one of the top risks too, in terms of protecting your bottom line, meaning there is a lot of litigation around this still, and it is around the photographs. So it's the same spiel we've been giving for more than 10 years now about photographs. Don't use a photograph in your listing unless you have permission to do so, and written permission to do so. If you are unsure, don't use the photo, because there are photographers, or more likely photograph owners, who have a collection of photographs that are out there looking for infringement. And infringement is per se, meaning if you used it without permission, you're liable. So make sure that you have permission to use the photographs. Secondly, you all use IDX websites, right? That is another major benefit for you and consumers about cooperating in an MLS. And so on your IDX website, you do not want to be liable for someone else's infringement. You are displaying a photograph on your website, but it is not your listing. You did not post that photo. You do not want to be liable for that reproduction. The only way you will not be liable for that is if you adhere to the Digital Millennium Copyright Act safe harbor provisions, and you have the proper copyright notice takedown and notice information on your website, or your MLS perhaps has orchestrated it such that it's included in your IDX feed. So make sure that you are complying with the Digital Millennium Copyright Act, DMCA safe harbor, and these videos here will tell you exactly how to do that. Disclosure and misrepresentation. This is relatively new. I mean, it's not a new issue, but it's new to the list of hot topics because we have seen a huge increase in litigation awards or settlements regarding claims of not disclosing issues of material fact. Or misrepresenting issues of material fact. And so this is a good reminder for you and your agents to know what's material and to make sure that it's properly disclosed. Independent contractor status remains a top issue, a litigation issue. So if you are facing challenges from these plaintiffs' attorneys or others, issues about teams, that definitely falls into the independent contractor / employee risk bucket. We have a number of resources there for you. Last but not least is a hugely expensive risk, and that is the TCPA and the Telephone Consumer Protection Act and the Do Not Call Act. Those acts have really kept plaintiffs' attorneys in business. Those acts provide that if a business violates either by either texting a commercial message without consent or calling someone who is on the do not call list, there is liability. And so what we're seeing is this cottage industry of lawyers claiming class action status against brokers across the country, mostly in Florida and California, but across the country, for texting consumers about listings available, texting agents about recruiting, trying to get them to come to their business or take their education, any commercial message that that the agent did not have, or the broker or the sender did not have prior express permission to send, will likely get you into trouble under the TCPA. So please check these tips out and tools for reducing and avoiding your risk. Again, a good place to start is a window to the law, which explains the risk and the risk reduction steps quite succinctly.